Testing 1, 2. Peter Piper 1, 2. No, I should know it, but... Testing 1, 2. Peter Piper 1, 2. So
hello.
Maybe you were right there.
See? The AV Club. AV Club, what can I tell you?
Except in testing 1, 2. Testing 1, 2. Peter Piper 1, 2. Testing 1, 2.
Quorum being present, the Subcommittee on Health, Employment, Labor, and Pensions will come to order. Before we move into the subject of today's hearing, I want to start by saying I wish this morning would have started differently. Many of us are still processing the tragic events that have occurred this morning, and I know that our thoughts and prayers are focused on friends in the hospital at this moment, including a former staffer of mine, a graduate of Adrian College, Adrian, Michigan, my home county, and a young man who became like a third son to Sue, my wife, and myself, who's in surgery at this time and in very grave condition. It's very hard to imagine that such a tragedy could have occurred while our colleagues were doing something as simple as practicing for a charity baseball game before they came to work. The horrific events of this morning have made us all pause and give thanks for the brave men and women of the Capitol Police who serve and protect us all, whether members of Congress, whether staff members or visitors to this great institution of democracy. As well as thanks for a strong Capitol Hill community with friends and family who have rallied together in support of those who have been impacted by the events of this morning. Members of this Capitol Hill community are here because they are answering a call to serve the American people. And the best way we can help those impacted by the events of this morning is by continuing to serve our fellow citizens. Additionally, I want to thank our witnesses, the audience members and fellow members of the committee for their cooperation with the rescheduling of our hearing, which undoubtedly has caused some disruption of plans. I will come back to my opening comments following some other comments that will be made by my colleagues here. But I would also like to do something, and I just request, with all due respect of my colleagues, that you would allow me, as a Christian, and I certainly respect all faiths, but as a Christian, I believe in the power of prayer. And it's not normal that we open our committee hearings in prayer, but I would like to do that this afternoon. Father, we don't come to you just in a moment of silence. We come to you as a loving God who hurts when your created beings go through challenging, difficult, painful circumstances, and ultimately circumstances that indicate there is still evil. And so today, even before we carry on with the business that we have been sent here to do, we call upon you to address these very unique concerns, thinking of the Capitol Police personnel, Matt Micah, and Steve Scalise, who are all in various processes of having their wounds, their injuries, the life-threatening things cared for. We ask that you would protect them, that you would sustain them, and that you would heal them, that you'd be with their families who are hurting and worried and concerned, families who will have this impact upon their lives for days, weeks, maybe years to come. We ask that you would sustain them, and for the community here in this Capitol, that you would undertake for needs as well. But Lord, we pray as well that you would restore our country, that you would heal our divides, that you would bring us together, and that you'd create a nation indivisible with liberty and justice for all. I thank you that you can hear and answer those prayers. And it's in the name of Jesus I pray. Amen. I would now yield to my friend and colleague, the ranking member, Mr. Sablan, for your comments.
Thank you very much, Chairman Wahlberg. I know that words are insufficient at this time and I can only imagine how you feel at the when you found out that Matt, one of your former staff, was wounded this morning. I was horrified also when Seth came to pick me up, give me a ride to a meeting we had. One of our own colleagues, staff, and former and Capitol Hill police officers were were shooting victims in a practice for tomorrow's game. And my heart goes out to the families. My prayers goes out to Steve, Congressman Scalise, the staff, the Capitol Police, their families, and all of those affected by this morning's horrible event. And just as Speaker Ryan said earlier today, when one is attacked, we are all attacked. I pray that there's no more such incidents in the future. But for you, Mr. Chairman, I know this is also personal, and I'll keep you in my prayers as well. I yield back.
I thank the gentleman. Now I'd like to recognize the ranking member of the full committee, Mr. Scott, for any comments on this morning that you would like to share.
Thank you, Mr. Chairman, and thank you for the opportunity to speak briefly about this morning's shooting in Alexandria. Like you, I was shocked and saddened to learn of what happened this morning to our colleagues gathered to practice for the annual congressional baseball game. Our thoughts and prayers are with Majority Whip Scalise, Zach Barth, with Congressman Roger Williams' staff, and your former staffer, Matt Micah, now Tyson's Foods. Also, the two Capitol Police officers who heroically intervened and were shot while responding to this incident, and of course, to all of their families. I remain hopeful that each of the victims will recover. Mr. Chairman, violence has no role in our political discourse. While we have disagreements over policies and sometimes get into heated debates, each of us and our staffs are motivated by a shared common principle. There's love for our country and the desire to make the lives of the people we represent better. I've seen that every day that I've had the honor and privilege to serve in this chamber, and I wish the American people could actually see firsthand the close bipartisan friendships that are developed here. It's my understanding that the congressional baseball game will go on as planned tomorrow evening. That's great news. This annual event has always been an opportunity for Democrats and Republicans to come together for a friendly game of baseball while raising money for local charities. This moment of levity in Washington is always needed, but certainly now more than ever. So I thank you, Mr. Chairman. Yield back.
I thank the gentleman, and you're absolutely right, and that's why this hearing is going on as well. We will not have evil stop us from doing our business we've been called to do. And Bobby, I hope you noticed I didn't pray for victory for the Republican side tomorrow. We won last year, but it's been a long time coming, so we'll see what happens tomorrow evening. But I think we'll all win by playing the game, absolutely. Well, this brings us to our hearing this morning as we work to address pressing issues that impact hardworking Americans, and I recognize myself for an opening statement. Our first subcommittee hearing of the 115th Congress was focused on the need to restore balance and fairness to federal labor policies. This has long been a priority for House Republicans, and today we are taking the next step in our efforts. The National Labor Relations Act was signed into law more than 80 years ago to protect the rights of workers in union elections. Congress understood workers deserve the opportunity to make informed decisions on union-related matters, and that employers deserve a level playing field with labor leaders. the NLRA established important protections, it also created a neutral arbiter, the National Labor Relations Board, to serve as a fair and objective referee over labor disputes. But that certainly has not been the NLRB we've come to know, I believe, in recent years. Instead, over the last 8 years, the board launched an activist agenda aimed at tilting the balance of power toward powerful special interests. Unfortunately, it came at the expense of the hardworking men and women who keep our economy moving. Decision after decision by the NLRB restricted the rights of workers and employers. Make no mistake, both Republicans and Democrats respect the right of workers to join a union. I was a union worker. But workers also deserve the right to make a free and informed decision in that matter. That means workers should have the chance to hear from both sides of the debate. And I hope we can all agree workers deserve to make a decision in an environment free of threats, coercion, or intimidation. However, the NLRB's actions over the years sent a different message. For example, in 2015, the board implemented a rule designed to rush employees into union elections. The board dictated that workers should only be afforded as few as 11 days to make a decision on whether or not to join a union. That's roughly a week and a half to consider all the facts and consequences before casting a vote on a personal issue that directly impacts on an employee's job and paycheck and future. Meanwhile, employers were given just 7 days to find legal counsel and prepare their entire case before the NLRB hearing officer. That's nearly impossible for most employers, let alone a small business owner. With such a short time frame, employers hardly have a chance to communicate with their employees. But limiting debate and stifling employer-free speech for the sake of speeding up union elections was precisely what the board had in mind, I believe. It's no surprise that union elections have been organized 38% faster since this new rule took effect. To make matters worse, the rule jeopardized the privacy of workers and their families. The NLRB forced employers to hand over the private information of their employees to union organizers, including home addresses, phone numbers, email addresses, work locations, and work schedules. At the same time, workers and employers have been hit with micro-union scheme that empowered union leaders to gerrymander the workplace. This new standard has created division in the workplaces across the country, buried small business in red tape, and undermined job creation. It's long past time to put an end to these misguided policies. That's why I was proud to introduce the Workforce Democracy and Fairness Act to restore the rights of workers and employers in union elections. My colleague, Representative Joe Wilson, has also introduced the Employee Privacy Protection Act. This important legislation will safeguard the privacy of America's workers and give them greater control over their personal information. In addition, Dr. Phil Rowe introduced the Employee Rights Act to ensure workers aren't stuck in unions they no longer support. The bill would modernize the union election process, require periodic union recertification elections, and give workers more control over how their union dues are spent. These are all common sense proposals that will protect the rights of workers and restore balance and fairness to the rules governing union elections. I hope we can have a thoughtful discussion as we review these positive reforms, and I will now yield to Ranking Member Sablan for his opening remarks.
Thank you, Chairman Walberg, for holding this hearing today. I thank and welcome all the witnesses also for being here with us today. And at my first hearing as ranking member of this subcommittee, I stated that the purpose of the National Labor Relations Act was to strengthen unions as an institution in our economy to ensure that wealth is more fairly shared. When working Americans are empowered to collectively bargain with their employers over wages and conditions of employment, productivity gains can be linked to wage growth. However, the three bills under consideration today sabotage workers' ability to organize and collectively bargain for a better life. Make no mistake about it, taken together, these bills are not just union-busting bills. They're union elimination bills. Workers should have a right to a fair union election. In any normal election, you have to win a majority of those voting to win. H.R. 2723 would require the union to win a majority of all eligible voters. This means that every person who does not vote is counted as a no vote against the union. And my colleagues all know that this is not how our elections work, and that many of us would not be here if we had to get 50% plus one of all eligible voters in our elections. H.R. 2723 would mandate an election every 3 years if 50% of the workforce changed on whether employees should even have the right to have a representative and collectively bargain. Workers already have democratic rights under union constitutions. They can vote on their collective bargaining agreements, and under existing law, they can vote to decertify the unions if they do not want one. This bill would force each local union to misdirect its resources to battle for its very existence on a continuing basis instead of building a stable collective bargaining relationship. So it is fundamentally at odds with the NLRA's stated purpose to promote collective bargaining. Employees have a right to be fully informed in a union election, yet both H.R. 2775 and H.R. 2776 would overturn the NLRB's election rule that promotes transparency by assuring that the union and the employer have the same employee contact information. H.R. 2776 would provide three major impediments to union elections. It would impose a minimum 35-day waiting period just to hold an election, even in instances where the employer and employees agreed to a speedier election. It would delay pre-election hearings for at least 14 days. And it reverses a rule that requires litigation on some issues to occur only after the election. The bill would enable frivolous litigation, which is often used for the purpose of delay. In fact, employer law firms openly encourage companies to engage in pre-election litigation as a way to buy time to allow the heat of the union's message to chill prior to the election. Mr. Chairman, I ask unanimous consent to introduce a document from the Jackson Lewis Law Firm website into the record.
Without objection and hearing none, it will be entered.
Thank you. The National Labor Relation, the NLRA, seeks to assure employees the fullest freedom of association, and also by directing the National Labor Relations Board to determine the unit appropriate for the purpose of collective bargaining. Yet this bill directly empowers employers to gerrymander the bargaining unit by allowing them to add voters who do not share an overwhelming community of interest with those seeking to form a union and might have no interest in joining a union. As we learned in our February 14 subcommittee hearing, the NLRB's specialty healthcare decision ensures the voting unit cannot be gerrymandered by the employer. Eight separate Federal Circuit Court of Appeals have approved this decision, and not one has overturned it. Specialty healthcare has not led to the parade of horribles trumpeted by those who claim that micro-units would proliferate and create havoc. The median bargaining unit size has remained at approximately 26 in the years before and after the specialty decision. But before I close, I ask my colleagues not to be deceived by the names given to these union elimination bills. The Employee Rights Act takes rights away from employees. The Employee Privacy Protection Act does not protect intrusions of an employee's privacy from their employer. And the Workforce Democracy and Fairness Act undermines fair and democratic union elections by allowing unnecessary delay in elections based on gerrymandered voting units. This is the 27th hearing that this committee has held on unions since my colleagues, the Republican majority took over. And I hope in the future we can spend nearly that amount of time on retirement security, job safety, and other issues more pressing to the American people. While we may disagree, I want to thank the chairman for allowing regular order on these bills. I also want to thank each of the witnesses for taking the time to prepare their testimony and appear here today. And I thank you also for your patience because of the delay. Finally, I want to recognize a young lady, Nadia Ali, who is here today. Nadia is interning in my congressional office this week as part of a program with the Girl Scouts of America. Welcome, Nadia. And I yield back, Mr. Chairman.
I thank the gentleman. Now we've heard the parameters of the issue, and that's the way it should be. And Nadia, welcome. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearings to be submitted for the official hearing record. It's now my pleasure to introduce our distinguished panel of witnesses. Ms. Nancy McKeague from my home state of Michigan is Senior Vice President of Employer and Community Strategies and Chief Human Resources Officer for the Michigan Health and Hospital Association, and not a stranger to this panel. Welcome. Ms. Karen Cox is a cycle counter handling inventory at an auto parts storage facility in Dixon, Illinois. Welcome. Mr. Jody Kalmine is General Counsel at the Communication Workers of America. Additionally, Mr. Kalmine is a former staffer here at the committee for the minority. Welcome back. Mr. Seth Borden is a partner at McGuire Woods LLP, representing management in labor and employment matters. Welcome. I'll now ask our witnesses to raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses all answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system. Most of you have been through this before, but it's like the traffic light. When it's green, keep going in your 5 minutes of testimony. When it hits yellow, begin to wrap up. You have a minute remaining. And when it hits red, don't be like me, just sliding it through, but finish your thought as quickly as possible, and we'll have opportunity to ask questions. It'll probably bring further opportunity to finish your statements. And so now let me recognize our first witness for the first 5 minutes of testimony, Ms. McKeague.
Thank you, Mr. Chairman. Good afternoon to all of you, and my sympathies to you, your staff members, and those who protect you for the situation this morning. Good afternoon, Chairman Wahlberg, Ranking Member Sablan, and the members of the committee. It's an honor to be here to discuss legislative reforms to the National Labor Relations Act. I serve as Senior Vice President and Chief of Staff for the Michigan Health and Hospital Association, or MHA, a nonprofit association advocating for hospitals and the patients they serve throughout the state of Michigan, and I appear before you today on behalf of the Society for Human Resource Management, or SHRM. Mr. Chairman, SHRM has always supported balanced labor management relations and believes an employee's decision on unionization should be based on relevant and timely information as well as free choice. Additionally, HR professionals have a responsibility to understand, support, and champion employment-related actions that are in the best interests of both the organization and its employees regarding third-party representation by labor unions. Unfortunately, the NLRB's ambush rule substantially shortens the period of time when a representation petition is filed and when an election is held, while severely hampering an employer's right to exercise free speech during union organizing campaigns. The rule also cripples the ability of employees to learn the employer's perspective on the impact of collective bargaining on the workplace. Consider, for example, that MHA allows employees up to 5 weeks to complete their annual benefit open enrollment, a friendly, non-controversial process that requires open dialogue between the employer and employee so both parties understand their health care elections. During this time, our employees have access to our providers so they're fully educated on any potential changes and the impact those changes might have on them or their family. This engagement provides our employees assurances that everyone's best interests are served. Although MHA has never experienced an organizing effort, I know SHRM members that have, and it's clear to me that a similar amount of time and focus would be needed to educate supervisors, staff, and employees about the rights, requirements, and our perspectives on the organizing drive. But the ambush rule would greatly diminish the ability of employers to adequately respond because it allows for an election within 11 days of a petition being signed. Now contrast this with the ability of unions to prepare for their entire organizing campaign before it's made public, which clearly creates an imbalance between the rights of employees, employers, and labor organization in the pre-election period. This imbalance is compounded for small employers who may lack an HR professional or access to legal counsel, and for multi-state employers who may have decentralized operations, making expedited communication with employees very difficult. Given these concerns, SHRM appreciates the chairman's leadership in introducing H.R. 2776, the Workforce Democracy and Fairness Act, to restore fairness to union elections, providing both employers and employees ample time to review a union petition. Now I want to take a minute to discuss employee privacy issues associated with the Excelsior list. SHRM is deeply concerned that the ambush rule requires employers to provide personal information to union organizers, including home addresses, home and cell phone numbers, without employees' consent once a union petition has been signed. Mr. Chairman, this is abhorrent, and it goes against everything that HR professionals have been trained to do without providing any safeguards for the information being shared with union organizers. Therefore, SHRM supports H.R. 2775, the Employee Privacy Protection Act, to address these privacy concerns and allow employees to choose how they want to be contacted if a union petition is signed. Finally, SHRM is concerned with the interplay between the NLRB's specialty health care decision and the ambush rule. Their concurrent existence provides labor organizations the ability to effectively target any industry or subgroup with a union petition. As outlined in my written statement, MHA has been advising hospitals across the state to prepare for this type of micro-union organizing activity because the success of any hospital is dependent on the ability of its staff members to work as a cohesive unit with mutual respect, and this decision threatens this vital component and empowers union organizers to create division and discord among professional employees. In closing, Mr. Chairman, SHRM looks forward to working with this committee to advance H.R. 2775 and H.R. 2776. Importantly, these bills would modernize the election process while providing employees the privacy they desire, while also restoring the delicate balance between the rights of employers, employees, and labor organizations. Again, thank you for this opportunity, and I look forward to your questions.
Thank you. Now I recognize Ms. Cox for your 5 minutes of testimony.
Chairman Wahlberg, Ranking Member Sablon, and members of the committee, thank you for the opportunity to testify today. My name is Karen Cox, and I'm here today from Dixon, Illinois, a small town from about 2 hours west of Chicago and the boyhood home of former President Reagan. Today, I work at an auto parts storage facility in Dixon, but I was previously employed at a cold storage facility in Rochelle, Illinois. For those of you who have not worked in cold storage, a typical day involves wearing full-body freezer gear and using a stand-up forklift to move pallets into and out of a storage freezer. My story begins in the spring of 2012. Rumors started going around about a union trying to come into our workplace. To be specific, this was the Retail, Wholesale, and Department Store Union, or RWDSU. I didn't take it that seriously because my coworkers and I were pretty content with our jobs. Soon we learned we were going to have an election. I was not particularly happy about it, but I thought at least we had time to educate ourselves and have a fair vote. But then I came into work one day and I was told the union was in and we were not going to have an election. The company had recognized them through a process called card check. This bypasses a secret ballot election, eliminating employees' rights to make a real choice for or against a union. I had never heard of this before, and it angered me. To me, it was un-American, and many of my coworkers agreed. Several employees had signed cards because they had been told they would just receive information about the union. They didn't know that if the union got enough signatures, 50% plus one, the company could recognize them and they could come in without an election. I had no experience with labor law and no clue what to do. After several phone calls to the National Labor Relations Board, I eventually got in touch with a lawyer from the National Right to Work Foundation who helped guide me through the process to remove the union from the workplace, which is called decertification. It requires collecting signatures from 30% of the coworkers in the bargaining unit. I had to do this on my own, in break areas only, and during non-working hours. It was a frustrating process, and I dealt with intense pressure from the union. In November 2012, I made the 2-hour trip to Peoria and filed the first petition with the NLRB. On my way back, I got a phone call from my dad. He told me a union rep contacted him and mentioned something about people losing their jobs and said that I needed to settle my grievances. My dad said, "Watch your back," because that was a threat, and I was shocked. After I filed my third petition in June 2013, we were granted an election. It was held a couple months later in August. However, since the union had appealed, we were unable to see the results, and the ballots were locked up until a decision was made on their appeal. A year later, we were still waiting on that decision, and the union contract that they negotiated for us was basically the company handbook. We were paying dues for something we already had. After several more months of waiting, in the spring of 2015, the NLRB finally made a decision. They concluded that we did not deserve the decertification election because although the union had a year to bargain and had even scheduled a contract ratification before I filed the petition that got us the election, they still had not had enough time to bargain. The ballots were destroyed, and we will never know the results. Today, I work at a different storage facility, but my experiences with the union at my last job will be with me forever. I am not anti-union, but I believe that all employees deserve a fair and secret vote on whether or not they want to join a union. That's why I support the Employee Rights Act, which guarantees a secret ballot vote. I want to ensure that other employees don't find themselves in the situation my coworkers and I were in, stuck with a union we didn't have a chance to vote for, and that is difficult, if not impossible, to remove from the workplace. Thank you for your time today, and I'd be happy to answer any questions.
Thank you, Ms. Cox, for your testimony. Mr. Calamine, welcome, and I recognize you for your 5 minutes.
Thank you, Chairman Mulberg, Ranking Member Sablon, and members of the subcommittee. My name is Jody Calamine. I'm General Counsel of the Communications Workers of America. We represent hundreds of thousands of workers in the private and public sectors across the United States, Puerto Rico, and Canada. Thank you for the invitation to testify today. And before I begin, I too want to express my shock at the events this morning. On behalf of myself and the communications workers, our thoughts and prayers are with all the victims this morning. It's a horrific, heartbreaking event that we had today. As you said not long ago, I used to work for the committee. It feels very funny sitting in front of you instead of behind you, but it's great to be back. I wish it was under different circumstances. I wish it was about a bill that would bring us all together. I wish it was about a bill that would bolster workers' rights. I wish we were here to consider a bill that would allow workers to freely exercise the full breadth of their bargaining power so that they can negotiate a better life for themselves and their families, to share in the wealth that they help create in this country. And I wish we were talking about a bill that would allow more workers to stand up and fight to bring jobs back to the United States. I wish. I wish. Instead, the committee is considering 3 bills that, in my view, are nothing but bad news for American workers. And so I must speak out against them. I will try to stay measured about this. I worked on the Hill for 11 years, and all that time, I never saw a bill as extreme and provocative and anti-union, anti-worker as the Employee Rights Act. Hands down, it is the most far-reaching assault against workers' organizations that I've seen introduced in the U.S. Congress in modern times. I was beside myself when I read it. Taken together, as they are presented at this hearing, these bills are a very loud alarm bell. In provision after provision, an already tilted playing field is tilted even further against the American worker. Briefly, here's what they do. The default way that workers organize a union in the private sector is with an NLRB election. The bills do their best to rig that election against workers and their unions. For example, they try to block workers from communicating with a union before an election. If an election happens, the bills stuff the ballot box with anti-union votes by counting every person who doesn't vote as an anti-union vote. Congressional elections aren't run that way. If they were, few, if any, members here probably would have won their elections. These bills work hard to delay union certification elections, to give employers more time to campaign, while creating a new decertification process that can be triggered by the employer and for which these bills tolerate zero delay. If you're a worker trying to get a union, these bills make you wait. If you're an employer trying to destroy a union, these bills give you the fast track. These bills allow employers to gerrymander the elections, to pack the voter rolls with workers who haven't been involved in the organizing drive and didn't petition for the election because the employers hope these workers will be no votes. And if workers try to escape this unfair government-run process by negotiating a voluntary recognition agreement with their employer, well, these bills won't permit it. They strip workers of the least conflict-ridden way to win union representation. These bills contain at least 5 different ways to drain union treasuries with pointless expenses. These bills strip union members of control of their own unions and outrageously give that control to employers and non-members. These bills seek to criminalize strikes and do their best to make being a union member an identity crime. I would be happy to answer questions about how the bills accomplish these ends, but I think the more interesting question is why. We've seen this across the country, many assaults against workers' rights to organize and collectively bargain in state houses, in the courts, and here. Labor unions win workers higher wages, better benefits, safer working conditions. That's our mission. Labor unions fought for and helped win things like minimum wage increases, health and safety protection, sick leave, family leave, Social Security, and civil rights, and we do stand in the way of their repeal. Labor unions call out unfair trade agreements and fight every day to stop companies from outsourcing jobs overseas and to bring offshore jobs back home. Workers joining together and fighting for a better life, that's one of the things that made America great. Unions fought for and won the American dream for millions of Americans over the last century. We're the single best private sector mechanism for raising workers' wages. Unions are your fellow Americans. Our membership cuts across race, gender, and ethnicity, party lines, pulling people together for a common project to look out for one another. We have a right to exist. Workers' voices matter to an individual company, to the economy, and to our democracy. No one can make America great again without us. Thank you.
I thank the gentleman, and I recognize Mr. Borden for your 5 minutes of testimony.
Good morning, Chairman Wahlberg, Ranking Member Sablon, and distinguished members of the subcommittee. It is a great honor and privilege to appear before you today. I want to echo the sentiments of the rest of the panelists and indeed some of you. My family will keep you all and your colleagues in our thoughts and prayers as we go forward. My name is Seth Borden. I'm a partner in the New York office of the law firm McGuire Woods. I'm not appearing today on behalf of any clients, however, and my testimony does not necessarily reflect the views of McGuire Woods or any of my colleagues. I've been practicing traditional labor and employment law for 19 years, representing employers of all types and sizes in a variety of industries across the United States before the National Labor Relations Board. A copy of my firm bio is provided with the written version of my testimony. The board's final rules, effective April 2015, overhauling representation election procedures, and the board's 2011 decision in specialty healthcare cast aside standards and procedures that had worked for decades. To turn a phrase, the board sought to fix something that wasn't broke in an effort to facilitate private sector union organizing. Passage of H.R. 2776, the Workforce Democracy and Fairness Act, and H.R. 2775, the Employee Privacy Protection Act, be a significant step forward to reversing these unnecessary and misguided policy changes, restoring the proper balance of rights and interests that had worked sufficiently for most of the board's history. The board's 2015 rule all but eliminated pre-election resolution of very significant legal issues like eligibility and unit inclusion, deferring litigation until after the election. In addition, the board implemented new time targets, reducing the pre-election period during which employees can learn and contemplate their decision to as few as 13 days. These changes limit employer free speech protected by Section 8C of the National Labor Relations Act and infringe on the Section 7 rights of employees to refrain from union activity. Postponing resolution of important legal issues until after an election only serves to enhance union electoral success by leveraging employer uncertainty and risk. H.R. 2776 would restore the pre-election hearing process. It would require a hearing absent agreement of the parties, provide time for the parties to prepare, and allow for the creation of a complete evidentiary record on all relevant and material issues expected to impact the outcome of the election. The board's 2011 specialty healthcare decision announced a new standard for determining whether a bargaining unit proposed by a petitioning union is appropriate. It cast aside presumptions which were the result of decades of practical experience in case law development and opened the door to so-called micro-unit organizing, whereby unions are the ones that can gerrymander a larger workforce and cherry-pick smaller units best suited to organizing success. The potential proliferation of micro-units within a single workplace does not promote, but rather threatens industrial peace and stability. It is all but certain to restrict an employer's ability to meet operational demands via efficient, flexible staffing, limit cross-training and promotional opportunities, and lead to higher customer prices and budget pressures. H.R. 2776 would reverse this misguided policy direction and restore the board's traditional community of interest analysis. It would provide additional stability and mitigate the ability of future boards to misuse newly announced standards by expressly incorporating these traditional factors into the body of the statute. These standards are far more consistent with the express terms and intent of the NLRA and had effectively met expectations for decades. The board's 2015 rule also forces the employer to turn over extensive personal employee contact information. Now, within 2 days after a direction of an election, the employer is now required to turn over the eligible voters' names and mailing addresses, as well as all available personal email addresses and all available home and personal cell phone numbers. These requirements needlessly violate the Section 7 rights of employees to refrain from union activity and the expectation of privacy employees have when providing personal contact information to their employers. More importantly, these days, no one is immune from the risks of hacking, phishing attacks, and identity theft, all of which increase with the volume of unwanted email or text messages directed at employees. Finally, many employers simply do not have all of the required information in one location or in a single common format for compiling and emailing in a 2-day time frame. H.R. 2775 will restore the 7-day time frame for the careful compilation and transmittal of employee information to the board, which worked sufficiently for nearly 50 years. Moreover, it would afford employees the choice of which method of contact each would prefer. This puts the choice of showing interest in sharing private contact information in the hands of the employees, where the statute would place it. For all these reasons, the subcommittee should move expeditiously to passage of H.R. 2776 and 2775 to fundamentally correct the unnecessary and misguided direction of the last 6 years. I look forward to your questions.
Thank you for your testimony. Thanks to each of you. And now noting that the witnesses pretty well kept to the time period, I would say the same thing to my colleagues here. Of course not the one I'll recognize first, and that's the chairman of the full committee, Ms. Fox. We welcome you for your statement.
Thank you, Mr. Chairman. As chair of the full committee, I just want to take a moment to thank everyone for accommodating our time change today, especially the witnesses who came from out of town. As Mr. Wahlberg noted in his opening comments, this is a very sad day for this House. I know we're all praying for our colleagues, members of the staffs, and the brave Capitol Police officers who suffered such a terrible act of violence this morning. But I truly believe that the best way we can honor our friends who are in the hospital or recovering with loved ones this afternoon is by doing what they would be doing if their day had not taken such a tragic turn, is by doing what all of us came here to do, and that's the people's work. So I do want to thank again everyone, our colleagues on both sides of the aisle, for being here. Now I'd like to ask some questions of our witnesses. And again, thanks to all of you for being here today and providing your valuable testimony and staying within the time frame. Ms. McKee, there's obviously a concern among workers that the ambush election rules require employers to turn over to unions a number of pieces of personal information, including workers' home addresses, phone numbers, personal cell numbers, personal email addresses. This rule also puts employers in a difficult position. Can you give some examples of the burdens the 2015 changes to Excelsior list pose for employers? Additionally, what types of problems arise from needing to provide more information only 2 days as opposed to the prior 7-day standard?
Yes, thank you very much. As most of you are probably aware, because you've been in the position of being on the giving side of that information stream yourself, we compile a lot of information about our employees, and it may be in a couple of different databases. So we have, home addresses, home telephone numbers, cell phone numbers when they give them to us. We have the same information about their dependents. We start collecting Social Security numbers as soon as they're issued on their infants. We have military records. We have background check information. We have all sorts of sensitive information, and they're stored in a variety of different ways. What the problem it creates for me as an HR professional is that these employees trust me to keep that information confidential, because with the wealth of information I have, I can become them if I wanted to, for purposes of applying for a credit card, getting a mortgage, doing anything that I shouldn't do with this. The chief rule I have for our HR team is that to misuse or leave that information out where it's available to somebody else is a dischargeable offense. In order to provide the Excelsior list information, I have to sort out from that what's being asked for on the Excelsior list. I have to check to make sure that it's accurate, because if it isn't accurate, I can be fined for that. Employees don't always update the information with me. For instance, a lot of my employees now, while I have a landline listed for them, they no longer use a landline, so I just have a cell phone. They certainly don't update the cell phone if they get a secondary cell phone. So it takes me a while to go back through that to make sure that it's as complete as it can be. And I only have 110 employees. So I can only imagine what it's like at a larger enterprise, which is more likely to be the target of an organizing drive.
Thank you very much. Mr. Borden, over the last 8 years, the National Labor Relations Board made a lot of changes under the facade of helping workers. However, it appears to some of us that these changes actually hurt those they're intended to protect. For example, it seems to me the board should be able to review the decision of a regional director before a union election takes place. Can you give some examples of why pre-election board review is essential?
I'd love to. I think that this is, in particular, an area where the board's 2015 rule, got it exactly wrong. I think that when there are important questions of unit eligibility, inclusion, important legal issues that are likely to impact the conduct of the parties in the weeks leading up to an election and possibly impact the election itself, it is in everybody's best interest to have those issues resolved at the outset. Nobody wants to play an entire game only to find out after the final buzzer that the rules have been completely changed and all of a sudden Tom Brady is on the other team and all his touchdowns count for them instead. No one wants to find out the rules that they're playing under after the fact. And I think that the restoration of the pre-election hearing process here to resolve those issues, is someone a supervisor or not? That has very, very serious legal implications for an employer and the people with whom it can communicate and how it communicates during an election contest. Issues of eligibility, voter eligibility. The Labor Board does a phenomenal job of protecting the secrecy and the privacy of the ballots cast, but my experience has been that employees don't want to hear, oh, your eligibility is being contested, so you can vote in this election, but your ballot may become the source of litigation after the fact. That has a chilling and intimidating effect that is unnecessary if we were able to resolve those issues at the outset.
Thank you, and I just want to say, Ms. Cox, thank you for the courage you showed in the actions you took and for being here to share that. Thank you, Mr. Chairman. I yield back.
I thank the gentlelady, and I recognize the ranking member, Mr. Sablan.
Thank you very much, Mr. Chairman. Mr. Calamine, Jody, welcome back. It's good to see you again. Thank you very much for appearing this afternoon, and thank you for your many years of service to this committee. Your statement says that while the 3 bills under consideration today are relatively short, they are packed with malicious intent. You pointed out that the true goal of the legislation is to weaken or eliminate unions. So if these bills were ever enacted, what would become of collective bargaining and what would be the effect on income inequality in our nation?
It's well studied that unions help push wages up, not just for the companies that are unionized, but their competitors then are forced to increase wages and benefits. The good example would be in the auto industry. UAW has done a good job of setting standards for wages, and it has helped push up wages across the industry. It would, in an immediate sense, if unions were eliminated, when we bargain higher wages. We have, I think, a 27% or so difference between what union members make or what unionized workforces make compared to non-unionized workforces. It makes a huge difference in terms of, or that difference is even more dramatic when you look at the wage differences between union and non-union workers who are women or African American or Latino. If these bills were to become law and organizing were to become next to impossible, especially under the Employee Rights Act, we would see income inequality, just to get to the bottom line here, exacerbated, and all the social and economic ills that come along with that.
All right, and you HR 2723, if it becomes law, would require a majority of all eligible voters in order to certify the establishment of a union, but would only require a majority of those actually casting ballots to decertify a union. So that means that all non-voters are no voters when it comes to electing a union, and you alluded to saying that some of us may not be here. I agree with you, my first two elections, probably not here. But is there a double standard that sets up different tests for certification and decertification elections? Or is this simply what it appears to be, a blueprint to eliminate unions?
Well, it's absolutely a double standard in this bill. What the Employee Rights Act does, as you said, if you are a non-union workforce trying to become union, to do that, you would need the votes of all eligible voters, or I'm sorry, a majority of all eligible voters to win. If you're a union shop going through this automatic decertification process that is introduced in this new bill, to decertify, you only need a majority of the votes cast. So it's far harder to win a union, far easier to eliminate a union.
So then, if I understand HR 2723 correctly, there's a mandatory requirement for union recertification elections also every 3 years. If there is a 50% employee turnover since the previous union election. So doesn't this effectively amount to a decertification process, even though there was no decertification petition filed?
Right. Even though no worker may have wanted to decertify, there's now this process that causes an election to happen when the workforce changes by at least, or I guess, one more than 50%.
Right.
There's an automatic decertification, probably triggered by the employer's changes to the workforce.
Right. And Jody, you very well know me. I'm from the insular areas, the territories. In this committee, we're calling the outlying areas. On Sunday or Saturday, there was an election in one of the in Puerto Rico, where 93% of those who went to vote voted aye for statehood, but only 26 or 27% of the population, of the registered voter population, voted. So is that a majority of voters? I mean, is that how we would run union elections also?
Yeah, I don't follow exactly, but it doesn't sound like it.
All right. Mr. Chairman, my time is up. Thank you.
I thank you, gentlemen. Now I recognize the gentleman from Georgia, Mr. Allen.
Thank you, Mr. Chairman, and thanks to our panel for being here and talking about this important issue. Mr. Borden, I'm interested to know about the impact of the combination of all these board changes in recent years. For instance, what is the relationship between specialty health care and the NLRB's ambush election rule, and what effects have you seen since the decision and the rule were handed down?
Sorry. I think it's hard to even focus on just the interchange of those two changes, because there were so many changes during the last 5 or 6 years where the board changed drastically long-standing principles of law that are critical to an employer's approach to these issues, and critical to the balance of the employees' unions and the employers' rights. The joint employer standard, which was overhauled significantly, the multi-employer bargaining unit cases whereby third-party employees can be included with the regular full-time employees of an employer without consent of all parties, and even some of the more discrete issues like use of the employer's equipment for organizing purposes. These all cast aside 30, 40, 50 years of precedent and the manner in which employers were accustomed to doing things. When you add in the fact that now on a compressed time framework, where the employer has only a few days after the filing of a petition to discover all of the legal issues that they may have to approach, consider these new legal frameworks, compile all of the evidence that might be necessary for assessing and addressing those issues to the board in the hopes of getting a hearing to create a record and preserve issues. And then you couple that with the further complication of the specialty health care standard that they'll be forced to consider, and the need to do all of these other things like compiling all this data that Ms. McKeague spoke about in order to get it to the union within just 2 days after that direction of election. It eats significantly into the resources and the focus that employer has to exercise its free speech rights for whatever time frame it might have before that election. And it makes it harder to comply with all of the technicalities.
Well, certainly, Ms. Cox, in your testimony, you brought some examples about some of the issues you dealt with. You know, we're talking here today about legislation that would correct some of these things, Mr. Borden, that you talked about. Let's talk about the overwhelming community of interest test. When does the board use this test in determining bargaining units, Mr. Borden?
Well, the answer to that question differs as to whether you meant before 2011 in the specialty healthcare decision or now. The overwhelming community of interest language was plucked out of an unrelated standard that the board employed traditionally in accretion cases, which is the standard that's applied when you have an existing bargaining unit in place represented by a union, and the union or employees petition for the inclusion of another group of employees into that existing bargaining unit without an election. And the board had traditionally looked at that and said, we will only allow that to take place if those additional employees share an overwhelming community of interest with the already represented employees. Okay. The specialty healthcare case plucked that language out of context and applied it to the traditional test that turned the traditional test on its ears to change and add a significant burden to employers when they wanted to challenge the hand-picked unit that a union petitioned for.
Does the Workforce Democracy and Fairness Act adequately address this issue? Do you believe it?
I think it does. I think it does by, as I said in my opening comments, by putting the traditional community of interest factors, the test that had been used for decades prior to specialty, expressly into the language of the statute. It would provide that clarity and that stability, the inability of a future board to approach this issue unilaterally and kind of whimsically change the standard.
I yield back.
I thank the gentleman, and I recognize the gentleman from New Jersey, Mr. Norcross.
Thank you, Chairman, and our thoughts go out for what happened to a remarkably sad day. But I want to start out with what the speaker talked about, and that is the relationships and working together. You on this panel know that I worked as a business agent for close to 2 decades. I've lived what you're talking about today. And my hand is extended, and any time you'd like to hear a view from the opposing side who have been to the NLRB, who had filed elections. But let's look at the facts. It almost seems like we're in some alternate universe of how bad the employer has it. I'm going to bring to your attention the percentage of union workers over the course of the last quarter century. When those are telling us you have it so bad, we're down to 10%, the union side. You can see it behind you. So all these horrible rules, yet you're still winning all the elections. Facts count, and this is what I want to be talking about. You know, We, as a country, many years ago decided that people would have a voice in the workplace, that they would be able to join unions, have collective bargaining. Well, there's been a tremendous drop over the course of since 1983. And there's just so much to cover here today, but I want to try to focus in on a couple of those. First and foremost, when we talk about access to the employees, the employer has unlimited access. They have any number of meetings that they want to put together, those captive audiences. It's up to you. And you're suggesting that you don't even know your own employees. And to say you can't pull the electronic information out, I think my 12-year-old grandson could pull that out. This is not burdensome. In fact, union membership has gone down since you put this rule into effect. I know the lawyers like it. This creates a lot more opportunities. But this is just trying to create fairness. There was a statement made by Ms. Cox that talked about the employees who had signed the authorization card to receive, they said they thought they were going to receive union information. The fact of the matter is that can be used as an unfair labor practice. And I have one right in front of me that talks about exactly what it says. I hereby accept membership in the above-named union, and on my own free will, I hereby authorize. So, Mr. Calamine, is there anything in this that you would say is deceptive?
No, it's very plain language.
It's ones that's used universally because the card could be thrown out if it's not following the rules, right?
Yep, all cards have language along those lines.
Why do you think we're in this position today? The ambush rule, as they call it, where's the problem with that if the elections are still by the majority being won by the employer?
Well, I think I appreciate the question because it allows me to, I think, provide more context for what's going on here. It's not as if when the petition is filed, I would be surprised if there's a case out there where, or that there are very many cases out there anyway, where an employer did not know workers were trying to organize a union until that moment that petition was filed. An organizing drive takes a lot of work, and it is very difficult because the union does not have access to the workplace. The employer has total access. So there's a lot of attempting to get people's attention outside, to meet with people outside of work. And as Ms. Cox described, when you're a union supporter trying to organize a union, you're also confined to non-work areas, non-work time when you're in the workplace. So it's very difficult. So I don't view this as ambush. I think what happens is when the petition is filed, I think it sends a signal to the employer, uh-oh, they must now have the votes. And now's the time to really start campaigning, to switch those people back. So the more time they have after a petition has been filed, the better off they are. I think there have been studies showing that that's the time when unfair labor practices are more likely to be committed in that time frame. So I think that's what they're buying time to turn the election.
5 seconds less on the support bill, but again, when we can work together, that's how our country will grow, not by creating the good guys and the bad guys or the union and the employer. We really could have the conversation and work this out. I yield back.
I thank the gentleman, and now I recognize the gentleman from Michigan, Mr. Mitchell.
Thank you, Mr. Chair. Ms. Cox, I don't want you to get bored there. We wouldn't want that, especially all the time you waited. And thank you to all of you for rearranging your schedules today. I'm aware of concerns that employees have that sometimes they don't feel adequately advised what the consequences of signing a card given to them by union organizers, union representatives. In your experience, did the union provide you and your fellow employees with accurate information about what it meant to sign the card, and what recourse did you have?
Many of my coworkers were very upset after they found out we were not going to have an election, because they were told, no matter what it said on that card, they were told that if they sign that card, they will get information about the union whether or not they wanted to decide to have a union or not. And they did this, actually, nobody was doing this petitioning outside of work like I did when I was doing it on the other side. These people were doing it on work time and inside the building during work hours. They weren't supposed to, but, you know, they were sneaky about it.
And you didn't think that was quite as balanced as it should be, I assume?
No, I do not. I don't think that's fair at all.
Let me ask you a question. Getting out information, your personal information, as part of the union organizing drive, the current system has basically any of the identifying information, short of your social security number and your address, all your telephone numbers, all of that is required to be turned over as part of the organizing drive. What's your opinion of that?
The union having my address and everything?
Address, all your phone numbers, your cell number, they're entitled to all of that based on the current rulings.
Well, I don't agree with it. I do know that after I started petitioning, many of the union reps were visiting homes and upsetting many of my coworkers because they came to their door and tried to persuade them against me.
Did any of your benefits people come to your home to talk to you about your health insurance benefit or anything else?
No.
They didn't, but they're supposed to help you out as workers. You mean only the union organizers came to talk to you?
No.
Did the union come to talk to you about what the contract negotiation should be like later? Did they stop in to see your thoughts on that?
No, they did not.
So they only came by to make sure you signed the card so they could organize?
Exactly.
Well, I guess so much for being concerned about representing the employees. Ms. McKee, we talked about the distribution of information, the Excelsior list. My company had 650 employees. To be brutally honest with you, I'm not sure we could have ever complied with a 2-day turnaround with the information required by that list. More importantly, is there any other function that you had that requires you turn over a list of that extent of your employees to some other entity?
The only way I would turn over any of that other information would be under a court order.
And that would be as a result of some legal action for a subpoena?
Generally, the only other time I would get a request for that kind of information without the employee's consent would be under a pending divorce action or a child custody dispute.
But that would only be for one employee, correct?
That would be one employee.
One or
That's
two,
correct.
depending on the circumstances, right?
Yes, Mr.
But not all of your employees.
No, I've never seen a circumstance where it would be required for all of my employees.
And you've never, other than the union organizing activity, I've never seen it in my career other than this. It's the most unique thing I've seen.
Correct. And this is information that all of us teach our children not to hand out to anybody else because of the risk.
As a matter of fact, you're right. And when we obtain utility service, health insurance, I'll give you a long list, we in fact only provide specific information we want to provide for contact. We get to choose. But in this one instance, under the current rulings, all that information is released.
And that's my objection, is it's done without the employee's consent.
And to be direct and honest with you, it's my objection as well, which is why I support the legislation that would make this change and will urge us moving forward when it comes time for markup. My time has expired. I appreciate everyone being here. Have a good weekend.
I thank the gentleman. Now I recognize the ranking member of the full committee, Mr. Scott.
Thank you, Mr. Chairman. Ms. McKee, you mentioned some problems at the acute hospitals. Are there special rules for organizing bargaining units in acute care hospitals?
I'm not a specialist in bargaining. Most of my hospitals that are organized have very good, cooperative, respectful relationships with their bargaining units. And assuming that this goes back to the specialty healthcare decision, this is where I will agree with Mr. Calamine about specialty healthcare. I believe The Circuit Courts of Appeals, it was mentioned earlier, 8 of them agreed with the NLRB on specialty. I think that was a very fact-specific case dealing with a non-acute care facility and the bargaining unit, and I believe the circuit courts got it right. My concern on specialty, which has since been used to deal with micro units outside of the non-acute care setting, has been that it could be used if it isn't corrected on a go-forward basis in an acute care setting would be very dangerous.
Well, that's why there's special rules in acute care hospitals. Has your position taken, speaking of healthcare, has your organization taken a position on the Trump care?
Yes.
What is it?
The Michigan Health and Hospital Association has taken a position. SHRM, which I'm here to testify on behalf of, has not.
And what is that position?
The Michigan Health and Hospital Association is opposed to the Affordable Health Care Act, which the president has proposed.
Thank you. Mr. Border, you've indicated a need to get everything straight before the vote. If the subjects of the litigation would be moot because the number of votes in controversy are overwhelmed by the margin of victory, why shouldn't the vote go forward?
Well, I think there are, as I mentioned earlier, there are practical consequences and possible real legal exposure that employers are forced to undertake if they don't have the certainty of certain issues.
Right, but I mean, if you can argue about 1 or 2 votes here, 1 or 2 votes there, if the margin of victory was like hundreds of votes, why would you delay through various levels of litigation the vote to figure out whether or not those votes are eligible or not eligible, when all of those questions would be moot if there is a much larger margin?
I think because there are issues beyond simple inclusion or eligibility of certain voters that pertain to whether their vote will count or not. The issue of supervisory involvement is one that I mentioned, is the one that springs most chiefly to mind.
And if you're arguing about a handful of votes when the margin is hundreds, why would you want to delay appeal and wait for a final verdict?
Because it has nothing to do with the handful of votes. It has to do with the fact that if there are 10 or 15 workers who an employer deems to be supervisors, management, agents of the company, and the union contends are employees, failure to resolve that issue at the outset has far-reaching consequences. Now, as an employer, I'm forced to make a decision. I'm forced to either decide I'm not going to talk to these 15 people who I earnestly believe to be members of management during this campaign, deny them the information and my communications.
So if you can find side issues that would be totally moot if you could just get to a vote, you should delay the vote.
With due respect, I don't think the supervisory issue is mooted, and frankly, it threatens to undermine the vote.
It would be mooted if you're talking about a handful of supervisors and you're about to lose the election by hundreds of votes. Why should you be able to delay for months and even years an election? Mr. Kalaman?
Yeah, I was just pointing out, I think the question of whether or not somebody is a supervisor or not is if it's a real problem for the employer. It's been a problem for a long time because the organizing drive has been happening for a long time. You only get to resolve these questions at the end, and it's at the end of that campaign, that long campaign, whether the election is about to be delayed or not on some level. I also just wanted to make a point that with respect to all the information that the NLRB rules now have employers provide to unions, these bills do not protect employees' privacy from their own employers. That is, the employers can compel employees to give them their email addresses, their personal email addresses, their personal cell phones, et cetera, for purposes of use in the campaign. So one side, again, and remember that the reason this has become an issue for 50 years, getting this Excelsior list, is that the union is not permitted to come into the workplace. It might be a completely different debate if what we were actually debating was unions, and to avoid having to talk to workers outside the workplace, if unions were entitled to access to the workplace. That would be, and in some cases, that's what happens. Employers and unions will reach an agreement to provide for union access, but unions aren't entitled to that. So how are unions supposed to talk to the voters when the employers have the voters captive, essentially for captive audience meetings or throughout the workday, and talk to them all the time? There's just, this is just a matter of fairness.
Gentleman's
Thank you.
time has expired. Now I recognize the gentleman from South Carolina, the sponsor of H.R. 2775.
Thank you, Mr. Chairman, and thank you, Mr. Chairman, for your dedication and leadership that we'll be meeting today and with our thoughts and prayers with Congressman Steve Scalise, the U.S. Capitol Police, and then staff members. And I particularly am thinking of different offices like the office of Tim and Sue Wahlberg, that their office has been directly affected. And it's just so impressive to have a chairman who will continue on important issues as we work for the citizens of our country. God bless you. Thank you. Ms. McKeague, in your experience, are union organizing campaigns always started by employees, or is it instead a result of a union operative coming in from the outside? Can you explain the process?
No, they're not always started by employees, but there has to be a receptive employee for the union to get a foothold in the organization. So, generally, it's a little bit of both, and it, in my experience, tends to come from a receptive audience within our workforce. And it's generally more successful when there's been a relationship between an employee in one of our facilities and somebody from the union which wants to become recognized in the workplace. It can come about from a friendship or an existing relationship with an employer where that employee used to work, but it generally comes out of a cooperative working relationship or friendship that they've had someplace else.
I'm grateful. In my home state of South Carolina, we've recently had a organizing campaign at the Boeing facility in North Charleston, South Carolina, and it was really outside. And to the credit of the workers, the result of the most recent vote was 73% not to organize. And it was truly a credit of the workforce, a credit to the personnel there, such a positive environment, and we in South Carolina truly benefited. We now have nearly 9,000 people at that facility in North Charleston, and then the ripple effect for suppliers throughout the district I represent, for tubing, for interior, for the cable, and so we've seen a very positive result just recently in my home state. Ms. Cox, I want to thank you for being here today and sharing your information. I share your concerns about employee privacy. You and your father's experience with the threat made by union representatives shouldn't happen to American workers or their families. Yet there are numerous articles that cite similar occurrences. In a Washington Times article, Jennifer Parrish tells of how a person came to her house uninvited and became increasingly angry when she refused to sign his petition. The petition he wanted her to sign was indeed a union authorization card. The ambush election rule that we're discussing today requires employers to provide even more private information to union representatives than before. You mentioned your family has been being contacted. How did the union get that information? Given your experience, does the providing even more private information about the employee increase the possibility of greater coercion or harassment from paid union organizers?
I'm really not sure how they got my dad's even his name, because we don't share the same last name, and I was not living with my parents. I'm not sure, he must have done some research on me beyond my address and name.
Well, again, thank you for your courage of being here today. Mr. Borden, thank you for your service as a fellow attorney. I particularly appreciate your insight. And as we have legislation today, I appreciate your endorsement of the Employee Privacy Protection Act. And can you give any other reasons why this is so important?
I think that beyond just the problems that the other witnesses have spoken to about turning this personal contact information over, is the manner in which some regions of the board have enforced these new requirements. And what particularly comes to mind is a case coming out of the Boston region, Danbury Hospital case, where despite the fact that within this 2-day time frame, the employer turned over every voter name, every voter home address, what had been required for 50 years to the union, had turned over phone numbers and/or email addresses for 94% of the bargaining unit. So that was far more than any union had gotten in any election in 50 years from an employer, because the board regional director found that they did not do an extensive enough search of individual department lists and separate lists that might be maintained even perhaps by individual managers to see if there were any other available numbers or email addresses available. He threw out the results of that election, disenfranchised 390 people that voted against that union. That is not a reasonable result within the framework of these new rules.
Well, thank you for your background very much. Bye-bye.
I thank the gentleman, and I recognize the sponsor of H.R. 2723, chairman of the Veterans Affairs Committee, and gentleman from Tennessee.
Thank you, Mr. Chairman. I want to associate my remarks with Mr. Wilson and his comments about what happened today. And I thank all of y'all for being here. Mr. Callahan, thank you for your years of service on the minority. I want to get a couple things in the record, Mr. Chairman, to start with. One, less than 10% of union members ever voted for the union they currently represent. Number two, since the so-called ambush election rule came in, the unions were winning at that time 68% of representation case elections, in contrary to what Mr. Callahan said. And as of fiscal year 2016, the first full year of the rule, when the elections were representation cases, it won 72%. I know as an employer, there's no way on this planet I could get to get an attorney, a labor attorney, in 10 or 11 or 12 days to represent me. There would be no way I could educate myself. I am completely disarmed. So I want to get that on the record. Number three, I'd like to get on the record is that the Railway Labor Act covers major airlines, and rail employment has the same absolute majority requirement in election for over 75 years. That's been going on. And to compare that to an election we have, which is going to get me to the secret ballot election, is that a congressman can't deduct anything from your paycheck. We can't force you to go on strike, and we can't have you fired if you don't follow the rules. There's a big difference. 44 years ago, right now, I'm 11 miles south of the demilitarized zone in Korea serving in the United States Army. I put on that uniform and left this country so that you could have a secret ballot to elect me, the president, and the union heads. And yet Ms. Cox can't get that if there's a card check. She can't have the same protections. And Ms. Cox, I think that bothers me more than anything, is that I think we need to have, this country was founded on the secret ballot. My wife tells me she voted for me. I don't know that for a fact because it's a secret election, a secret ballot. And I think that you as an employee ought to have exactly the same right. And I cannot understand why anybody at this dais would not insist that you have that right. And why somebody can check a card and then decide for you belong to an organization. I don't get that. And I want to ask you, you spoke very eloquently about this decertification process that you personally went through. but you took your own time to do that. You traveled to the NLRB office, and it appeared all to no avail. 2 years later, they threw the ballots out. And do you believe that individual employees are given a voice in the processes that you described in your testimony, or is the NLRB more concerned with the interests of unions and employers instead of the employee?
I truly believe that the NLRB was very biased and sided with the union. I mean, I don't know how the petition that I filed that got us the election was filed after they scheduled a ratification. They were done bargaining. So how can the NLRB tell me now that we didn't deserve that election because they didn't have enough time to bargain when they already were done? So
Why do you think that was?
why do I think?
Why do you think the NLRB ruled like they did?
I'm really
You
not
think
sure.
that was a fair ruling?
No, I don't think that's fair at all.
I think another thing
can
in the bill that I have here is a secret ballot votes for strikes. I grew up in a union household. My father worked in the United Rubber Workers Union, and I remember the strikes we went on, that he had to go on, where our family were deprived of income. Some of them went as long as 3 months. And, I mean, I can still remember those. We would go out and sand floors and do whatever we could to make a living to feed our family. And eventually, his company left the country. And here's a 50-year-old, after World War II, 50 years old, high school education and no job. And so I've seen where people have lost their jobs, not have higher wages, but no wages at all. And Ms. Cox, I think your testimony is incredibly compelling to me. When you didn't want this, you weren't afforded the rights that I think any employee ought to be afforded.
Thank you.
Mr. Bourne, do you have any comments on that?
I do not, other than to say that the Labor Board does usually do a phenomenal job of trying to protect the secrecy and the privacy of the ballots in those elections.
Why would they have thrown them away?
I think it's one of the things, frankly, that the Labor Board does best.
I yield back, Mr. Chairman. Thank you for your...
I thank the gentleman. And now I recognize myself for 5 minutes of questioning. Ms. McKeague, the ambush election rule is especially difficult for smaller employers. Are smaller employers particularly affected by the timetable of an ambush rule?
Yes, in my opinion, they are. Most small employers don't have an HR staff, certainly not a professional staff in most cases. And as was just mentioned, they certainly don't have a retained legal counsel that specializes in labor law. And in order to hire outside counsel, even if you were able to hire somebody in that first day or so, they have to do a conflict check in order to take you as a client. And that, of course, means checking you against everybody else.
How long would that take?
A minimum of 72 hours, depending on the size of the firm.
And you're talking of 7 days potentially that you have, right, to get this accomplished? Taking out those 72 hours?
Yeah, taking out those 72 hours, because you can't go over the facts of the case with a lawyer until you know that they don't have a conflict. So you're in a holding pattern until they can get that conflict check done. So you've lost 3 days before you can even sit down with outside counsel and go over it. So you can start to do some background work within your place of business, but if you don't have the internal expertise to do that, you're dead in the water for 3 days before you can even start to get up and running. So as the gentleman noticed, yeah, you are already past your 2-day period.
Yeah. And even for the employer with best interests, to make sure that fair disclosure is given out there and the employee of his or her business understands it very clearly, it is almost impossible, especially for the smaller employer to do the due diligence to care for their employees as well as their own setting to keep the jobs.
I would say for an employer of fewer than 50 employees, impossible. For an employer of 100 or fewer, still a very close call.
It's tough. Thank you. Mr. Borden, the Obama LNRB sought to tilt the playing field, as we've discussed, under the guise of helping employees like Ms. Cox in the direction of unions. In your experience, when do employers become aware of union organizing drives?
I would say that there's been that I've seen a varied experience there, to be candid. I think there are some employers, as Mr. Calamine suggests, that are aware ahead of time, that have a heads up. But just as much, I have seen that more savvy union organizers make a concerted effort to stay below ground for as long as they possibly can. And to use as much time, weeks, months, or years, prior to filing a petition, prior to alerting the employer to what's going on, to organize a group of employees that are going to drive the organizing effort.
And the ambush rule has made it even more challenging.
Well, it's made it more challenging in the sense that regardless of how much time ahead of the filing of the petition the union has been working quietly, the amount of time that the employer has after the filing of that petition has been significantly reduced.
Okay. Ms. Cox, thank you for sharing firsthand experience that you've gone through, you've walked through, and had a memorable, to say the least, testimony to share for this committee today. It's the most important perspective, I believe, to consider, how it actually works in relationship with the employee. In your experience, are the interests of employees and the interests of unions always the same?
I'm not sure what you mean.
Looking at how this came about in your life, was the interest of the employee and the interest of the employer the same, and especially in its impact upon you?
The interest of, like my interest as an employee compared to my employer?
Employer, correct.
I believe there's a difference, for sure. I mean, with the employer, it's a business thing.
Would it be safer to say, and I didn't want to make a trick question out of that, but would it be safer to say that the interests of employers, employees, and unions are all different?
Yes.
And so all ought to be considered
Yes.
in a timely fashion
I
that
agree.
ultimately brings about the best result.
Yes.
I see my
May I add
time has
something?
expired.
May I add?
I appreciate the answers. I appreciate the witnesses and the chance to respond to questions. But we've come to the end of the hearing. This is, as was mentioned earlier, an appreciation for regular order. This is what we wanted to do. We want the subcommittee to work and address it first, and I'm sure there'll be other discussions that go on. I know that's the interest of the chairman of this full committee on education workforce, to make sure that we deal with a very timely and important issue relative to employers, employees, and unions in a way that isn't just a pass of the hand, but we look at it and hear testimony. And so now I would turn and ask the ranking member if you have any closing remarks to make.
Yes, Mr. Chairman, and I want to thank the witnesses again for their testimony. As I noted at the outset, the right to collective bargain is key to ensuring a fair economy. Numerous studies show that income inequality has skyrocketed as union density has dropped. Today, private sector union membership is a little over 6%, and the legislation before us today is aimed at the extinction of private sector unions as we know them. Today, we have learned that the three bills under discussion are designed to sabotage any notion of a fair union election process. H.R. 2723, the so-called Employee Rights Act, rigged union election by counting every eligible employee who did not vote as having voted no against union representation. H.R. 27, and if I may note at this time, and with I have huge respect for the distinguished gentleman and my chairman of the Veteran Affairs Committee, the gentleman from Tennessee. I think he maybe has incorrectly claimed that the Railway Labor Act currently uses the ERA's rule of making non-voters vote against the union. That, I think the rule was amended in 2010 to require a bare majority of votes and not voters, like he stated. H.R. 2775, the so-called Voter Democracy and Fairness Act, prohibits unions from having the same access to employees' contact information as the employer during the election process, thus preventing employees from being informed about union representation. And as one of the witnesses stated, that although she didn't fill the form, she thought, and many employees thought, that filling out the form, and which is written in both English and Spanish, was to provide information. But it actually hereby also says that I hereby accept membership in the above-named union and of my own free will, and hereby authorize it to act for me as a collective bargaining agency in all matters pertaining to wages, hours, and conditions of employment. And this is a union of the Retail, Wholesale, and Department Store Union Districts Council, UFCW. And I'd like to insert this for the record, if I may, Mr. Chairman.
Without objection and hearing none, it will be inserted.
And H.R. 2776, the so-called Employee Privacy Protection Act, mandates arbitrary waiting periods that delay elections and empower employers to gerrymander the voting composition of bargaining units by adding employees who have expressed no interest in joining the union. So instead of relentlessly attacking voters' rights and retaliating against employees who want a union, the committee should be focusing on efforts to strengthen workers' rights to organize, raise the minimum wage, and provide paid sick days. I'd like to ask also unanimous consent, Mr. Chairman, to insert for the record a letter from the United Food and Commercial Workers Union and the Retail, Wholesale, and Department Store Union District Council. If no objection, Mr. Chairman.
Without objection, it'll be inserted.
I would also like to ask unanimous consent that the graph used by Congressman Norcross be inserted in the
Without
record.
objection, it'll be inserted.
I also like to ask unanimous consent that a press release from the new Illinois members at Americo win first contract, like a letter from a press statement from RDWSU, the union, which won a 5-year collective bargaining agreement at Americo in Illinois, because that document explains the union won better pay, scheduling improvements, and a stronger grievance process. And these gains would not have been possible had her co-workers followed the lead Ms. Cox and the National Right to Work Committee and decertified.
Hearing no objection, that'll be inserted as
And
well.
finally, I'd like to enter for the record, I ask unanimous consent to enter for the record a letter from Mary K. Henry in behalf of the 2 million members of SAU opposing the three bills before us today. She notes these bills would lead to complete subversion of fair elections.
Hearing no objection, that'll be
And,
inserted.
Mr. Chairman, despite that we may have disagreements, again, I am very grateful that you're following a regular order. I want to thank witnesses. We may have disagreements, but I think those disagreements are honest, and I respect that you took the time to prepare and come today. I apologize for the delay. It was unavoidable, and I yield the balance of my time.
I thank the gentleman, and I too want to thank the witnesses. You've added value to our discussions, and we know where to find you if we need any further information as well on either side of the issue. Let me just state very clearly for the record that this is not an attempt to eliminate unions, not at all. And sometimes it's classified as an either-or. That isn't the case. From my own experience, and subsequent to my time working at U.S. Steel Southworks, number 2 electric furnace, right down on the borders of Lake Michigan, unions have had some extremely positive impacts. And going back to steel mills now and seeing the difference in some of the working conditions that I just took for granted, frankly worried about it. It's changed. And there has been positive impact, I know, as a result of union efforts for their workers. But seeing the graph that was brought by Mr. Norcross earlier on, I would contend that there's also a rationale there that says that unions and the impact, the positive impact they've had, may indeed have had an interesting impact of workers seeing them work themselves out of their job. The benefits that have been achieved, and now saying, tell you what, like Ms. Cox, I would at least like to know how it's going to be better for me than what I have right now. And if indeed that justifies the union dues that will be taken out, and also how those dues will be used relative to political efforts, et cetera. And I think that's what the 3 bills we're looking at today are going toward, and saying, let them make their choices with the fullest information possible, as fairly as possible from both sides, not rushed, not jammed through, and the people that are truly interested are the ones who will make the decisions on what comes forward. That's all we're asking. And this indeed is regular order in the process of discussion. So we'll continue it on. We'll see where it takes us from here. But bottom line, we want to make sure that everything we do here promotes more, safer, more secure, an increased number of opportunities of choice for employees to have with employers as well. And so we'll continue looking at this. I want to again say thank you. With no further issues to come before the subcommittee today, I call this meeting adjourned.